Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner. In today's video, we are going to discuss section number 26 and 27 and specifically dying declaration under Bharatiya Sakshya Adhiniyam.
All right, let's dive right in. What happens when the only person who witnessed a crime is dead? I mean, it's a huge question, right? It gets to the very core of our justice system. Today, we're going to unpack a really powerful legal tool that deals with exactly these kinds of life or death situations. And we'll see how the new evidence law, the Bharatiya Sakshya Adhiniyam, stacks up against the old one on this critical issue.
Yeah, it's a pretty chilling thought, isn't it? You've got a crime, but the one person who could point the finger, they're gone. Forever. So what happens? Does the case just go cold? Does a criminal get to walk free? This is honestly one of the biggest challenges our legal system has to face. Okay, so to really get the solution, we first have to understand the problem. And that problem has a name: hearsay evidence. Now, this is a huge deal in trial law, a real cornerstone, and it's something courts are, let's just say, extremely careful with.
So what is hearsay, really? Well, in simple terms, it's just secondhand information. It's when a witness gets up there and says, well, my friend told me that she saw, instead of I saw. It's basically courtroom gossip, and our entire legal system is built to run on hard facts, not he said, she said. So, you might be asking, why is the law so strict about this? Well, it really boils down to three big reasons. First, the person who originally said it wasn't under oath. Second, and this one is a game changer, you can't cross-examine them. You can't poke holes in their story, you can't question their memory or their motives. And third, if that original person was just making things up, they can't be charged with perjury. It's just a recipe for unreliable evidence. But here's the thing. What happens when that so-called unreliable evidence is the only evidence you have? Think about it. If you just toss it out, a guilty person could literally walk free. This is exactly why the law has to make a very smart, very necessary exception to the rule.
And that exception? It's now laid out in Section 26 of the new BSA. What this does is it creates a powerful carve-out, a specific pathway for these exact situations, where a key witness has died, gone missing, or just can't testify for some reason. The whole point is to make sure that justice doesn't die along with the witness.
Now hold on, this exception isn't just a free-for-all. It's built on two really solid pillars. First up is necessity. The court has to be absolutely convinced that this evidence is critical and that it would be lost forever otherwise. And the second pillar is reliability. There has to be something about the circumstances, something that makes the statement feel trustworthy, even without all the usual courtroom checks and balances.
So, to really see how this works in practice, let's zoom in on its most famous and, let's be honest, most dramatic example. We're talking about the dying declaration. Okay, so a dying declaration is exactly what it sounds like. It's a statement made by someone who truly believes they're at the end of their life, and they're explaining how it happened. The law gives these final words a ton of weight. The thinking behind it is ancient, really, that a person who is about to meet their maker has zero reason to lie. All the small earthly motives, they just fall away, and what's left, hopefully, is the truth.
And listen, make no mistake, this isn't some obscure legal footnote we're talking about. The Supreme Court made this crystal clear in a landmark case. A powerful, convincing, dying declaration can be enough all by itself to secure a conviction. That's just how significant this kind of evidence is, as long as the court is totally satisfied that it's truthful. Let's make this super practical. Imagine a victim is stabbed. With their last breath, they manage to tell the doctor, X is the one who attacked me. That statement, when the doctor repeats it in court, becomes incredibly powerful evidence against X. You can see how, without this exception, a crucial piece of the puzzle would just disappear.
All right, so this brings us to the big question, especially for all the legal pros and students watching. What's actually changed with the new Bharatiya Sakshya Adhiniyam? Is this a major overhaul or just a tune-up? Let's put the old law and the new one right next to each other and find out.
You know, this idea isn't new at all. It has a really long history. It started way back in English common law, then it was officially written into law here in India back in 1872. That was Section 32 of the Old Indian Evidence Act. And now it's just continuing its journey as Section 26 of the new BSA. It's a legal idea that has really truly stood the test of time.
Okay, so take a look at this.
When you really break it down side by side, the court principles are pretty much identical. The purpose is the same, making statements from unavailable people admissible. The people it covers, dead, missing, unable to testify, that's all the same. Even specific things like the dying declaration and business records, they're all still there, just with new clause letters. Really, the key change here is the language. The new law has been drafted to be a bit simpler, a bit more modern.
So, here's the bottom line. The crucial point to take away from all this is that the legal substance has not changed. If you were comfortable with Section 32 of the old Act, you're all set with Section 26 of the new one. The legal DNA, all that history, and all those court rulings, it's all been carried over, completely intact.
But let's not forget, allowing evidence that can never be cross-examined, well, that creates a huge challenge for any judge. It forces the court to perform a really delicate, really difficult balancing act.
Yeah, this is the very tightrope that a judge has to walk. On one side, you have the absolute necessity of getting this evidence in to make sure justice is served. But on the other side, you have the serious caution you need to take when you're relying on a statement that can't be questioned or challenged. It all comes down to the court having to meticulously weigh every single word.
And that really leaves us with a final question to chew on. It's one thing to talk about this law in theory. It's another thing entirely to be the one who has to apply it. So put yourself in that position. If you were the judge and the only real evidence you had were the last words of a victim, how would you decide? How do you put a value on words that can never, ever be questioned?
In the legal world, there are few things more dramatic or more powerful than a person's final words. A statement made right on the edge of death, pointing a finger at a killer. But how on earth does the legal system handle something so profound? Can someone's last breath really be enough to convict another person?
Okay, so here's our game plan. First, we're going to dig into this core idea of truth at death's door. Then, we'll check out the specific law that governs these final words. After that, we'll see how courts put these statements through. It's basically the ultimate reliability test. We'll also jump into some fascinating landmark cases to see how this all works in the real world. We'll even cover the weird twist of what happens if the person actually survives. And finally, we're going to tackle the big one. How much weight do these declarations really carry in a courtroom?
All right, let's start with the basics. Normally, a court won't listen to what one person heard from another. That's just hearsay evidence. But dying declarations, they're a huge exception to that rule. And you have to ask, why? Well, it all comes down to a really powerful belief about human nature when we're faced with our own mortality.
This is the question, isn't it? The entire legal idea behind dying declarations is built on the assumption that the answer is almost always no. The thinking is that the seriousness of that moment, well, it forces out the truth. And this idea is perfectly captured by a Latin maxim that has been quoted in courtrooms for centuries. Nemo mortuus presumitur, mantere. It basically means a man will not meet his maker with a lie in his mouth. This powerful idea is the very foundation of this entire law. So what's the court's actual thinking here? The Supreme Court of India laid it out pretty clearly. The logic goes like this. When someone knows their time is up, every hope they had in this world is gone. All the usual reasons for lying, greed, revenge, whatever, they're silenced. The mind is just pushed to speak the simple truth. At that point, what reason is there to blame the wrong person? Okay, so let's move from the philosophy to the actual law on the books. This whole concept is now covered under Section 26 of the new Bharatiya Sakshya Adhiniyam of 2023. And it's worth noting, this section pretty much carries forward the same core ideas that were in the old Indian Evidence Act of 1872.
So the definition is key. A dying declaration is a statement made by someone who believes they are about to die, and the statement itself has to be about how they ended up in that situation, because of their death or the circumstances that led to it.
Now here's the actual text from the new act. It says a statement is relevant if it's about the cause of his death or the circumstances of the transaction which resulted in his death. But here's the really interesting part, and this is what makes Indian law pretty unique. The law also says it doesn't matter whether the person who made them was or was not at the time when they were made under expectation of death. Now that is a huge difference from, say, English law, where the person has to know they're about to die.
And it's so important to get this. There's no single strict format for a dying declaration. It doesn't have to be some formal statement taken by a police officer. It could be something whispered to a doctor, a note scribbled on a piece of paper, or even an entry in a personal journal.
But, and this is a big but, just because someone made a statement doesn't mean the court automatically buys it.
Not at all. The court has a huge responsibility to look at it very, very closely. They put it through what you could call the ultimate reliability test.
So you can think of it like the court has this checklist. First, does the statement clearly identify who did it? Second, if the person made more than one statement, do they match up? Are they consistent? Third, was the statement spontaneous, or was it tutored? Was there a chance a relative or friend was whispering in their ear? And finally, and this is a big one, were they in a fit state of mind? Were they conscious and actually able to give a clear statement?
This fit state of mind test is absolutely crucial. The case of Nanda Ram versus Maharashtra really hammers this point home. In that case, a woman had suffered 95% burns and was on oxygen. The court had to seriously ask, could she really have been in a fit condition to give a reliable statement? They decided she wasn't. The court has to be totally sure the words are coming from a clear and conscious mind. And in that same vein, the court is always on high alert for a tutored declaration. If there's even a hint of suspicion that friends or relatives might have influenced what the dying person said, like in the Kumon Singh case, that statement loses all its credibility. It has to be the real, unprompted voice of the victim, period.
So all this theory is great, but let's see how these rules actually play out in the real world, with some incredible cases that have literally shaped this law.
So here's a wild question that a court had to figure out. Can a gesture actually count as a statement? It sounds a little strange, but what do you do when the victim physically cannot speak?
The facts of this case, Queen Empress versus Abdullah, are just chilling. A woman named Dulari had her throat cut so badly that she couldn't speak a single word. When a magistrate asked her who did it, she could only use signs and gestures to respond. The huge legal question was, can these signs possibly count as a statement in the eyes of the law?
And the court's decision was totally groundbreaking. It ruled that yes, the combination of the questions being asked and the signs she gave in response could be considered a verbal statement. This case established that a dying declaration doesn't have to be spoken words at all.
And what about timing? Does it have to be said right before death? Well, in the Sharad Sarda case, a young woman wrote letters to her parents saying she was afraid for her life. She died 3 months later. The court actually allowed these letters to be used as a dying declaration, saying that even with the time gap, they were directly related to the circumstances of the transaction that ultimately led to her death.
Okay, now for a really important legal twist. We've been talking this whole time about dying declarations, but what happens if someone makes a statement thinking they're about to die, and then they pull through?
This is a hard and fast rule in the law. For that statement to get the special treatment of a dying declaration, the person has to, unfortunately, have died from their injuries. If they live, the legal status of that statement changes completely.
But the statement isn't just thrown out. Instead, it turns into something called a corroborative statement under Section 160 of the new Act. What that means is, when the survivor gets on the stand to testify, that earlier statement can be used to back them up, to show they've been telling the same story all along and to boost their credibility. And this brings us to our final and maybe most critical question. We've seen what a dying declaration is, and we've seen how it's tested. But at the end of the day, how powerful is it really as a piece of evidence? And here's the bottom line. The Supreme Court, in the huge case of Kushla Rao versus the state of Bombay, made it perfectly clear. A dying declaration is not some weak form of evidence. It stands on the exact same level as any other piece of evidence. And if a court believes it's true and reliable, it can absolutely be the only thing needed for a conviction. So that leaves us with this final thought. The law puts a tremendous amount of faith in this idea that truth is spoken at death's door. It gives a voice to a victim when they can no longer speak for themselves, but it also puts this profound responsibility on the courts to make sure that those final powerful words are not only heard, but are also, without any doubt, true.
So let's start today's explainer with a really important question. I want you to imagine a situation where a witness has given testimony in a case. Now, can that same testimony be used again, maybe at a later stage of the same case, or even in a totally different case? This is exactly the kind of question our new law helps us answer. Today, we're going to be discussing Section 27 of the Bharatiya Sakshya Adhiniyam 2023. This is the section that deals with situations just like this, where a previous testimony can become relevant later on. What you see on the screen right now is the core principle of this section. In very simple words, it says that testimony given by a witness can be considered relevant in a later judicial proceeding as well. But, and this is a big but, there are some very important conditions that have to be met. You see, the whole purpose of this provision is to make sure that justice doesn't fail just because a key witness isn't available later. So what are these necessary conditions? Well, there are 5 essential conditions to apply this section, and understanding these carefully is absolutely crucial for your exams. Now, for this section to be applicable, all 5 of these conditions must be satisfied together. It's an all-or-nothing deal. First, the testimony must have been given in a judicial proceeding or before a legally authorized person. Second, that witness must now be unavailable. Maybe they've passed away, can't be found, or are incapable of appearing in court. Third, the parties in both proceedings, the earlier one and the later one, have to be the same. Fourth, the adverse party must have had the full right and opportunity to cross-examine that witness in the first proceeding. And fifth, the issues in both cases must be substantially the same. Remember, if even one condition isn't fulfilled, the section just won't apply. Okay, so we've got the theory down. Now let's see how this works in practice. We'll look at a practical example and a landmark case to make the concept crystal clear. Let's suppose a Mr. Sharma gives testimony in a property dispute trial. But before the case reaches the appeal stage, he unfortunately passes away. Now, because the witness, Mr. Sharma, is unavailable, and all the other conditions are also met, like the parties are the same and they had a chance to cross-examine him, the appellate court can consider his testimony from the trial court as evidence. This is a perfect, practical use of this section. The Supreme Court reinforced this concept in the landmark case of V.M. Matthew versus V.S. Sharma in 1995. In this case, the court held that the right and opportunity to cross-examine is one of the most important conditions. The court made it absolutely clear that if the opposite party didn't get a full opportunity for cross-examination in the first proceeding, then that witness's testimony simply cannot be used later. It's a fundamental principle of a fair trial. All right, let's get to the most important part for you, your exams. Let's take a look at just how important this section is from an exam perspective. Now here's a very important point you should note down. This section used to be Section 33 of the old Indian Evidence Act 1872. That very same principle has been continued in Section 27 of the new Bharatiya Sakshya Adhiniyam 2023. So the concept is old, only the section number is new. Please listen to this very carefully. For both judiciary prelims and mains, this section is extremely important. In your mains, you could be asked problem-based questions on its conditions. And in the APO exam, there's a very high chance of a direct question on this topic. So you have to prepare it well. Okay, before we wrap up this explainer, let's quickly revise the key points of this section, just to make sure everything is fresh in your mind. So there are 3 things to always remember. First, the section number. Section 27 of the Bharatiya Sakshya Adhiniyam 2023. Second, its core concept. Using old testimony when a witness is unavailable, but only if all 5 fair trial conditions are met. And third, its exam importance is very high. Here's a final thought for you. Out of those 5 conditions, which one do you think is so crucial that without it, the entire section would be pointless? Definitely give that some thought. For more judiciary-focused legal content, be sure to stay connected with us here at Ganga Education. Thank you.
Thank you for watching this session. If you found this lecture useful, do like, share and subscribe to Ganga Education. Keep learning, keep growing and stay connected for more law lectures.